Good evening and welcome to the English version of our program Para Ser Legal to Be Legal. Today we're going to talk about the 9 changes that have made immigrating to the U.S. harder in 2019.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
My name is Andrés Mejer and today we are here to answer your questions. So please subscribe to our channel, share our video, put any comments you have right below, and we'll try to answer them as quickly as we can. So let's jump right into it. 9 changes that made immigrating to the United States harder in 2019. Well, number 1 is reduce the number of asylum applicants. Trump wants to bar asylum applicants altogether, particularly from Central America. He calls them a scam. He calls it the asylum loophole. They're all criminals, rapists, and drug dealers. That's how Trump views Hispanic Americans, whether from Mexico or from Central America. So under Trump's plan, any immigrant that came across the border, legally or otherwise, by train, by car, walking across the border, anything but plane, can't apply for asylum unless they've already tried and failed in one other country. So, look, if you're a Mexican citizen, you can come to the border and ask for asylum. That's not a problem. But if you're from anywhere south of Mexico, like El Salvador, Honduras, Nicaragua, Costa Rica, Panama, you will be sent back to Guatemala and you have to apply for asylum there, be denied there before you can come to the U.S. Again, so 2 exceptions. 1, if you come by plane, because obviously you didn't cross over Guatemala, you went over it. 2nd is you're Mexican. So if you're Mexican and you're afraid, you fear persecution in your country, Mexico, the United States can't by law send you back to the country where you're saying you're afraid to go back to. But any place south of that is fair game. Now, so far, the courts have stopped this plan. We'll see what happens in the future. Many of these items are in litigation as we speak. The next one is Remain in Mexico program. Now, this is still how the Trump administration wants to reduce asylum applications. In the first scenario, you don't get a chance to file, period. No due process whatsoever. You know, you walked through Mexico, you walked through Guatemala and then went to Mexico and you didn't ask for asylum in Guatemala, they won't hear your case. They'll automatically send you back to Guatemala to make that application. Remain in Mexico program, well, this is where if you come through through Mexico, legally or illegally, meaning you come to the border and you say, I'm Andrés Mejer, I'm from Chile, but I'm afraid to go back to my country. They will send me back to Mexico to wait the adjudication of my case. They're even setting up courts in Mexico. Tent courts, which nobody has seen or has access to. And you don't get to see an attorney. And good luck trying to hire an attorney. How are you going to find an attorney familiar with American immigration law in Mexico? I'm sure there's many of them, right? That's a joke. No, there aren't many of them, particularly involved in removal proceedings, which never been done. So maybe they've done family-based petitions, but they've never done an asylum petition. They've never done cancellation. They don't have that background or that information. So how are they going to be able to help you? Well, that's the goal. Not for you not to get the benefit, not to get the advice, and get deported. And hopefully, if you know that you're going to have to stay in Mexico, well, hopefully you won't even come at all. That's the ultimate goal out of this. Number 2, deny residence to immigrants considered to be public burdens or a public charge. So in 2018, the government started implementing this for people seeking visas to the United States. Basically, look, the underlying principle, I think, is solid. So I understand that rationale. It's just the way that they're going about it, they're making it harder and harder and harder to immigrate to the United States. So in 2019, they tried to implement it inside the U.S. for those seeking green cards. Now, the goal is to deny green cards to people who have or are likely to receive government benefits. And that are likely to is a gray area that's really not defined. So the way that the regulation was presented says, look, in the past 36 months, meaning 3 years, before the application, how many months did you receive any government benefits? And each benefit was a point. So if you had 12 or more, you're disqualified. and you're going to have to wait another 3 years. So if you receive food stamps and you receive housing for 2 months, that's 2 benefit points per month, so 4 points in total. But, so you're not automatically disqualified because it's less than 12. But hey, maybe you are likely to need it again in the future, and because of that, you're disqualified. Did you have it or did you not in the past? That's easy. I got no problem with that. You shouldn't be getting government benefits, period. You know, if you're a victim of domestic violence or you're applying under the VAWA, I mean, there are exceptions to every rule, right? But in general speaking, you shouldn't have access to those benefits. And if you did, you're not going to be rewarded for it, right? That's essentially what they're saying. But the way that they phrase it is, well, you had it once, you may have it in the future. Now we're going to deny you. That's not kosher. That's not appropriate. And that's one of the reasons why the courts have stopped it so far. Now, number 3, pushing more people into deportation proceedings. What do I mean by that? I mean, you apply for anything, you're denied, you're put in removal proceedings. That's not the way it used to be. It used to be only if you're a priority, only if you're a danger to society, only if you're a criminal or a terrorist would you be put in removal proceedings. Not anymore. Every denial, 100% of the time, is now being put into removal proceedings. And that's not right. Let me give you an example. Let's assume you have a conditional green card. What is that? It means that you got your green card based on marriage. Your spouse, when she applied for you, you were married less than 2 years. So when you got your green card, they said, hey, we're only giving you for 2 years. 2 years from now, you're going to have to prove to us you're still together. That you're going to have to really give us more evidence to show that this is legitimate because you are a marriage of short duration, so that you're a higher likelihood of fraud. That's what the law says. You know, there's a suspicion of a lot of fraud, particularly on the immigration side, because I can go in front of a judge tomorrow and I'm married, but that doesn't mean that it's a bona fide relationship. That doesn't mean that I didn't pay her to marry me. So I need to prove that it's a legitimate relationship. When we went from hello to I want to spend the rest of my life with you. And that's what we need to show in that process. But let's say for purposes of conversation, you got your green card. It was only a 2-year green card. Everything was fine. Maybe you even have a child together. But last month, you guys had a disagreement, kicked you out of the house for whatever reason. You haven't spoken to her in the past couple of days. She doesn't show up at your interview. Now, in the past, they might give you another opportunity. Let's say you said, listen, we've had our disagreements and, she kicked me out of the house. I don't know what's going to happen. They could now flat out deny your petition and put you in removal proceedings. It shouldn't happen. It's not appropriate, but it can. Let's say your employer, you have an H-1B process. So you're an employment side petition. It's called a specialty occupation based on your education or experience. Your employer applied for you and you got work authorization for a period of time, usually 3 years. You can renew it at least one more time. Now, let's say your employer merged with another company and they didn't file the correct paperwork to document the change. You can get denied and be placed in removal proceedings. It's ridiculous, it's silly, but now a small thing became really expensive. Now, when you received your green card, let's say USCIS made a clerical error. Let's say 25 years ago, you were a beneficiary under your father's petition. So an employer filed for your father. At the time, you were under 21. By the time it was approved, you were over 21. And they put you down in the wrong category. Oops. So if you're in New Jersey, they'll deny, and you're applying for citizenship, they'll deny your citizenship. Nowadays, they'll say you were not lawfully admitted into the U.S. But if you're in other states, in other jurisdictions, they might do more than just deny your petition. They might put you in removal proceedings. That can happen. Now, let me give you another example. Let's say you failed to renew a status. Let's say your green card petition was conditional and you didn't file to remove those conditions in time. Let's say you have DACA and you submitted your paperwork late. What happens if you didn't sign the petition? What happens if you sent the wrong filing fee or you didn't send a filing fee? The government could now deny your petition flat out and put you in removal proceedings. In the past, they would point out the deficiency and give you an opportunity to fix it. Are they going to do it in the future? They don't have to. The law, the circumstances have changed now. They no longer have to give you that opportunity. Are they going to? I don't know. But that's the direction of where things are going. Number 4, using the courts to increase deportation. Now you ask me, how do you do that? The whole point of a court is you have due process, you have notice and an opportunity to be heard. Well, let me tell you. In the past couple of years, under Obama administration, and probably to a lesser extent Bush and Clinton, judges closed 350,000 cases that were deemed as a low priority. Not a flight risk, been here a long time, no criminal record. So they closed the case and stopped the removal proceedings. Well, now, Trump administration wants to reopen every single one of those. And they've narrowed an immigration judge's ability to end deportation proceedings. It's pretty much only where the government agrees that the matter should be closed. Well, nowadays, and let me put it in context. When you're in immigration court, who does the attorney that represents the government, what is his or her role? Well, that attorney works for ICE. The client is ICE. ICE is what's trying to deport you. So are they going to agree to close your case? Very rarely. I'm not saying it doesn't happen. It does, but it's very rare in those circumstances. Now, to speed up deportations, the government has created a quota of 700 case resolutions for every immigration judge every year. If they don't do it, well, they get punished. They could lose their job. They could make less money. If they remand cases too many to agencies like USCIS, same thing. They can get punished. If they get reversed, meaning if they make a decision that then goes up in appeal and their decision gets reversed, you get it. There's consequences. There's punishment. So the government is really cracking down on immigration judges and making their lives miserable because all that the government wants them to do is deport.